So let's have a look at what it's all about. First, some themes that are probably quite familiar if you've been involved with data protection. The concepts of personal data, special data, now called special categories of data, sensitive data, the data protection principles, the idea of processing, of having data controllers and data processors. All these concepts are carried over into the GDPR, for better or worse. One thing that's happened is that the concept of personal data, what is personal data, has been expanded somewhat in the GDPR. So, for example, it's now been put beyond doubt that certain online identifiers, such as cookies or IP addresses, will constitute personal data. In fact, there was a recent, this is probably already the case, but it's now made clear by the GDPR. There's a recent case which found that even dynamic IP addresses can be regarded as personal data if you have the possibility of being able to get hold of the identifying information from a third party, such as an ISP. So the fact that you don't know someone's name and address and date of birth and things like that, traditional identifiers, doesn't mean that we're not in the world of personal data. If you're able to track people over the internet through use of cookies or IP addresses, those involved in targeted advertising, for example, are very much in the world of processing personal data. Sensitive data, the special categories of data, pretty much unchanged. One thing that's been added is biometric data and genetic data, so data such as fingerprinting or facial recognition processing is covered as sensitive processing, where there is a higher level of compliance needed, and in some cases it's going to be quite challenging to see how processing of sensitive data can be carried out in certain environments. The core data protection principles, under the Data Protection Act we have the 8 data protection principles. Here we're speaking about 6, are broadly the same on the slide summarised. Hopefully many of those are familiar. Key ones being transparency, I'll come on to talk about that in a minute. Purpose limitation, so just using the data for the purposes that you've told people and not for anything else. Minimisation, only using data that is relevant and limited to what is necessary. Keeping the data accurate and up to date so far as necessary. Keeping data for no longer than you need it. Storage limitation, and of course, data security. So what happened to the other 2? I said there were 8 under the current legislation. It's not that things have been relaxed, it's that those 2 additional principles have been basically moved into core obligations under the GDPR. So they're still very much there. We're talking about data security and international data transfers, which were principles 7 and 8 under the current Data Protection Act. One of the key changes that comes in through GDPR is the fact that data processors now have direct responsibility under the legislation. Up to now, under the Data Protection Act, the party that's responsible for compliance is the data controller. Data processors who are engaged by controllers to carry out processing activities don't have direct responsibility under the legislation. They have responsibility to the controller by contract, but they're not statutorily responsible. That's all changing with the GDPR. So if you are a data processor, then you become directly subject to the GDPR, and many of the obligations will be directly applicable, and in some cases there can be joint liability between the data processor and the controller. So we're involved often with looking at data processor contracts between controllers and processors. Over the past few years, these have become more and more detailed, and that trend is going to continue. Data processor contracts under the GDPR will have to contain more detail. There will have to be discussions about allocation of liability between those parties, and so that's something very much that's happening now and will happen more in future. To process people's information, you have to comply with or have one of the conditions for processing satisfied. There are a number of conditions for processing, and they're broadly the same as those under the current legislation, but with a bit more detail added on top. So the conditions for processing that are most commonly used at the moment are either consent or legitimate interests, what's called legitimate interests. Most people think that if you're going to handle people's information, you need their consent to do so. Actually, that's not true. There are other bases for processing information. And in fact, relying on consent alone is probably one of the least secure bases for processing. Come back to that in a minute. But the idea of getting consent will become much more difficult under the GDPR than it is at the moment. As we show on the slide, there are a number of conditions that need to be satisfied, whereas at the moment we think that you can get consent by sort of opt-out or by as an implied consent. That will no longer be the case. Consent will have to be very clear, have to be an affirmative act, so having a pre-ticked box will not be good enough. There'll have to be a ticking of a box. You'll have to be able to demonstrate that you have consent, so there needs to be some ability to keep a record, and so that you can prove at some point in the future that you obtained consent, that there's an audit trail. Consent has to be, it can't be sort of collective consent for all sorts of things. So each individual type of processing or reason for processing will need its own consent. So separate consents for separate operations. And individuals need to have an easy way to be able to withdraw their consent. So consent needs to be as easy to withdraw as it is to give. One of the differences with sensitive data is that consent needs to be explicit. So whereas for ordinary data, personal data, it needs to be consent. For sensitive data, it needs to be explicit. The regulation doesn't really go into detail about what's the difference between between consent and explicit consent. But it probably means that the information you provide has to be extremely clear about what you're doing, that is the data you're going to be processing, and that the consent you've obtained is very explicit how you've obtained it. So a clear affirmative act again in terms of getting that consent. So I mentioned that consent's probably not the best. While it's good to have, it's great to have consent, it's probably not the most secure thing to rely on for processing, because of course people can withdraw their consent, or they can refuse to give it, they can change their mind. And so if you need to process people's information for whatever reason, maybe in the world of HR or your marketing, maybe consent is not always the correct basis or the strong basis. Good to have, but not necessarily completely to rely on. And therefore, there is what's called the legitimate interest basis. Again, very similar to the current legitimate interest condition. It requires you to carry out a balance between the interests of your organisation in handling that data as against the potential risks to the data subjects with regard to their data. And that particular balance, whereas before it was sort of carried out in your head, will now need to be much more clear and documented, and will need to be explained in privacy policies that you're relying on that and the basis for it. The GDPR does, quite helpfully in one place in the recitals, say that legitimate interests can be used for things like direct marketing, cyber security, and intra-group transfers, and things that you would expect like that. And so that's quite helpful to know that you can use that condition in those areas. So we're all familiar with looking at people's privacy policies and privacy notices and the like, and this is going to be continuing, and in fact is going to become much more extensive, and a lot of work will need to be done on privacy policies to bring them into line with the GDPR. One of the paradoxes of data protection is probably that a key requirement of processing people's information is that you're very transparent, that you let people know exactly what data you've got, what you're going to be doing with it, who you're going to give it to, and so on. And that is normally set out in privacy policies. And these have got, over the years, longer and longer and more detailed and more complex, with the result that although there's a requirement to be transparent, in practice, most of us don't bother to read these things at all, and we just simply tick boxes and move on without really understanding what's going on with our data. Apple iTunes privacy policy is longer than Macbeth. I don't know how many of us here have really sat down and waded through it and understood exactly what's going on with our data there. The GDPR, in a sense, says, well, we've got to do that, we've got to be transparent. And then in one breath it says, but we also need to give more information about the processing, more information than we give at the moment. We need to explain about legitimate interests, we need to explain about data retention periods, if we're doing international transfers, and we need to give information on the new personal rights that Laura will mention in a moment. So there's more to set out in privacy policies, so they're going to, if anything, get longer. But on the other hand, there's a requirement in the GDPR for privacy statements to be concise, to be written in plain, intelligible language. So it's going to be quite challenging to look again at these policies. And there are techniques that can be used. So, for example, layering of privacy data, only giving what information you need, general summary information, perhaps with access to more detailed information elsewhere. Just-in-time information, so relevant information in context with what's going on, and not necessarily all the information at that moment. And use of icons, maybe video information instead of the traditional text-based privacy policies. So I think we'll see lots of new ways of presenting information to make it as clear as possible what's going on with people's information.